TCS Research Center, and many more places. So we welcome Mr. Vikram Singh at Jain University for delivering this seminar for intellectual patent rights. So over to Vikram sir. So we are very thankful that you are giving this seminar. So you can start the seminar now.
Good morning, everyone. Good morning, Rinji ma'am. Thank you so much for such kind words. Without much delay, let's start with today's session. So, in today's session, we'll be covering intellectual property rights, and various kinds of intellectual property rights, which is patents, design, trademark, copyrights, and geographical indications. So, to start with, all of you might be using one smartphone or the other. A simple smartphone has lots of different intellectual property rights associated with it. For example, if I take example of a Samsung mobile phone, the technology behind touchscreen is a patented technology. The image processing feature, which lots of mobile phones today are capable of, is also patented technology. Samsung keyword itself is a trademark registered keyword. So there is a certain way in which this Samsung keyword is written on boxes or mobile phones. So it is a registered trademark. The design, the way in which various smartphones are designed today, we may find flip-flop phones, convertible phones, all those things. These all things comes under design registration part. Then we have user manual, software, ringtones specific to a particular company. All these are part of copyright regime. And then of course the motherboard designing, which comes under semiconductor integrated circuit layout. We'll be covering all these things in subsequent slides. It was just to give you a brief introduction about a simple smartphone has so many different intellectual property rights associated with it. Often we get confused between patent, trademark, design, and we use these words interchangeably, but it is not. Each word has a significant technology or a connotation attached to it. So to start with, what is intellectual property? We all know physical property is something which is owned by an individual or a group of individuals. So you might be possessing a land, a building, or your personal belongings, some expensive smartwatch, or your jewelry. All these are part of your physical property. Physical property can also be intangible, for example, stocks, bonds, etc. Intellectual property, how it differs from physical property is intellectual property refers to creation of mind. For example, a prosthetic leg which is developed by Dr. P.K. Sethi is intellectual property of Dr. P.K. Sethi. He built this particular invention. He worked day in day out. It was his intellectual creation which came up in the form of a Jaipur foot, commonly known as a prosthetic leg, which is commonly known as Jaipur foot, or it may be an ECG machine developed by Dr. Sanjeev Saxena. All these are intellectual property of a particular individual. It is work of intellect of that particular individual. Intellectual property can also be a literary and artistic work. For example, a Harry Potter novel written by J.K. Rowling, or maybe a song lyrics of by this collaborative. So all these are intellectual creation of the individual. There are various kinds of intellectual property, as we have seen in the case of Samsung smartphones, which can be patents, design, trademark, geographical indication, copyrights, and semiconductor integrated circuit layout. All these obviously we'll be covering these in subsequent slides as well. Now, having discussed about intellectual property, what are intellectual property rights? See, intellectual property we have seen is a creation of mind, intellect of a person. Rights basically refers to legal entitlement or privilege that an individual or a group of individuals have. Rights have no meaning until unless it has a legal backing behind it. For example, government gives you a right to work, but in order to apply this right to work right, you have a legal backing behind it. That legal backing is Mahatma Gandhi National Rural Employment Guarantee Act. Until and unless that right is protected by a law, a legal backing, that right has no meaning. You have a right to right to speech and expression, or right to constitutional remedy, right to life. All these rights are conferred by the Constitution of India, and it is mentioned in Part 3 of the Constitution, Fundamental Rights. So there is a legal backing behind all these rights. Similarly, right to education. Right to education is also provided legal backing by Right to Education Act 2009. So right has no meaning until unless you provide it with a legal backing. All the intellectual property all the intellectual property which I have mentioned in the previous slide, which is patent, design, trademark, copyright, and semiconductor, in order to provide a legal backing to all these intellectual property, Government of India has provided various legislation, legal backing law in order to implement effectively these particular intellectual property. What are those laws? So the Patent Act of 1970 provides legal backing to the intellectual property related to the field of patents. The Copyright Act of 1957 provides legal backing to the intellectual property associated in the fields of copyrights. The Trademark Act, Design Act, Geographical Indication Act in the year 1919, 2000, and 1999 respectively provides legal backing to design, trademark, and geographical indications. To start with, one of the most important intellectual property, patents. A patent is basically a statutory right which is provided for an invention for a limited period of time in order for exchange of full disclosure of the invention from making, selling, using, importing the patented product. What does it mean? It means the inventor of a particular invention has to first disclose his complete invention in front of the patent office. Only then he'll be provided with a limited period statutory right. This limited period in case of patents is 20 years from the date of filing. Once you get this patent certificate or patent right, you will be liable to make, use, sell, import your patented product within the territorial jurisdiction of the country in which you have filed the application. So patent is a territorial and exclusive right. There is no concept of global patents. So if you have filed a patent application and you end up getting one in India, then you can enjoy various rights associated with this particular intellectual property within the territorial jurisdiction of India only. If you have to enjoy statutory right with respect to your intellectual property in some other country, then of course you have to file an application within the intellectual property office of that particular country. So there is no concept of global patents or global intellectual property at present. The term of patents is 20 years, as I've already mentioned before also, from the date of filing, not from the date of grant of your patent application. The day you file your patent application is the day lifetime of your patent starts, if you end up getting the patent certificate throughout the legal journey of that particular invention. Google search algorithm, most of you might have you have used in everyday day-to-day life, is a patented technology. You can clearly see the name of this global Google search algorithm, method for node ranking in linked database. You can find name of the inventor, Lawrence Page. This Lawrence Page is none other than famous Larry Page, the co-founder of Google. You can also find the date when this particular application was filed in the in the US Patent Office. It was filed in January 9, 1998. You can also find the patent number, date of patent. I mean the date when this particular patent was granted after it ended in its legal course. You can search for this particular application by typing this application number on Google Patents. Similar to Google Patents, the Indian Patent Office also has its own patent database or patent search engine, which is called Indian Patent Advanced Search System. The link for which is provided in this particular slide. Now, all the patent applications which are registered in the Indian Patent Office and subsequently published after 18 months of duration, you will find collection of all those applications in on at this particular platform. Now, the advantage as a researcher to anyone, the advantage to a researcher is if he wants to pursue a particular field or he wants to develop a particular technology and see whether what all patent inventions has been filed in that particular domain in India, you have to refer this particular website. And suppose you are working in the area of machine learning. So in the area of in this particular column of complete specification, mention machine learning and hit the search icon. You will find all the patent application which uses machine learning technology or has a keyword machine learning in the complete specification, which is when filed in the patent office. So it's a very, a robust engine where you can, before starting your research, you can actually refer and get an idea whether you are going into the right direction or not, or whether your application would be granted, referring to what all inventions have already been made in that particular domain. So now, what is the legal course of action when you file a patent application? So patent life cycle has two broad stages. Firstly is the patent prosecution stage, another is the enforcement stage. Prosecution means the course of action which takes place in the intellectual property office or the patent office. Patent enforcement is the course of action which takes place outside the intellectual property office. So once you file a patent application, your patent application is scrutinized by the office. And if your application is found to be in order, complying with the rules and regulation of the Indian Patent Act 1970, your application will be proceeded for grant and you will get a patent certificate. Now, after getting the certification for your invention, if someone else tries to trespass into your intellectual property or infringes, which is infringement in patent intellectual property domain, it is called as trespassing. So, if someone infringes your intellectual property, you can actually approach court and prevent that particular person from doing so. There are two basic terms, pre-grant and post-grant, which I mentioned over here, although it is not directly related with the patent prosecution or patent enforcement process. I mentioned it over here because a lot of time people ask the patent once granted can be revoked or not. Well, yes, if a person has been granted a patent certificate and if someone else has if a person has been granted a patent certificate and if someone argues against the validity of that particular certificate, he has to file a post grant opposition or a pre grant opposition depending upon at which stage that particular application is at. So if a patent certificate is not granted up till that stage, he can apply for a pre grant opposition. And even if someone has got a patent certificate being granted, you can actually go for a post grant opposition and prevent misuse of the intellectual property. What constitutes a patent specification? So I've already told you in the previous slide, you have to give complete disclosure of your invention. You have to present complete disclosure of your invention in front of the patent office, and then only your application will be examined. So the complete specification is is basically comprising of two different things: description and claim part. A description in a patent parlance has various dimensions. It has a title, the name of your invention, background, the area in which you are working, summary of your invention, detailed description, abstract. Detailed description consists of all the steps which you have taken in order to reach that particular results. It also includes drawings, flowcharts, and all the other things. Claims is basically the heart of a patent application. It defines the boundary and subject matter of the patent that is to be sought and protected. A complete specification without claims is of no use because claims is the subject matter on which you will be granted patent ultimately. Can everything be patented? Well, of course not. There is certain limitations on your invention and your intellectual capability. There is a certain section in the Indian Patent Act, which is Section 3, which provides a list of inventions which cannot be patented. So invention which is contrary to public order or morality. So if someone comes up with a stone pelting machine, obviously it cannot be patented. If Balal Dev approaches Indian Patent Office with a revolving blade chariot, obviously cannot be patented. a guillotine which was used on a mass scale in French Revolution cannot be patented. Some frivolous inventions or inventions which are contrary to natural laws cannot be patented. So if someone claims to develop a machine which generates output without taking any input, cannot be patented. A machine which claims to be 100% efficiency, no, cannot be. Someone comes up with traditional, someone comes up with asking for asking for patent application related to traditional knowledge. For example, we know that turmeric is having some medicinal benefits. It helps in pain relief, skin, immune system health, digestive health. Cannot be patented because we all know it is a part of our traditional knowledge. Neem also has some pesticidal and insecticidal activities. Cannot be patented because we all know that it is a part of our traditional knowledge. Similarly, methods of human beings, treatment of human beings, animal surgery, diagnostic methods, all these things cannot be patented. So, cataract operation method, cleaning plate process, X-ray, blood diagnostic process, all these things cannot be patented. If MS Dhoni approaches Indian Patent Office and asks for trademark this his trademark helicopter shot cannot be patented. Bicycle kick of Ronaldo or whatever this Roger Federer is doing, all these things. So basically, method of playing games, mental act, all these things are not part of patent application. Inventions related to atomic energy, they are also not covered under, they are also not going to be covered under Indian Patent Act. So Section 4 of the Indian Patent Act specifically deals with inventions related to atomic energy. This atomic energy cannot, inventions related to atomic energy cannot be patented because India ensures development of atomic energy for peaceful purposes. So it does not allow research to private individuals in this particular area. Also, there is a threat to security and welfare of the country. So it does not allow public participation in the area of atomic energy. Now, who can apply for a patent application? If there are four categories specifically, if you are working in a research lab of any organization, you can directly approach the patent office, intellectual property office, and apply for uh, and submit an application on your behalf. Assignee of true and first invention on your behalf, the research lab also can directly approach the organization, the intellectual property office, and register for a patent registration. Legal representative of any deceased person and patent agent. So there are four categories of individuals who can apply for patent certificate. What is the bare minimum requirement in order to file a patent application? So I'm telling you very crudely. I'm not going to the specifics of each and every forms because there are 30 different forms in order to file, which are used for various purposes for filing a patent application. I'll not be discussing all the 30 forms. I'll be discussing only the bare minimum forms which is required for filing a patent application in the office. So Form 1 is the first form which every individual needs to apply. Form 1 contains all the basic details of the applicant. So your name, roll number, contact details, name of the invention, which organization you belong, all these things, inventors which are involved, all these things are mentioned in Form 1 of Form 1 while filing. Form 2 contains, 2 also known as complete specification, provides brief details of your invention. So your summary of invention, drawings, complete description, all those things, the complete description part of your invention is mentioned along with Form 2. Form 3 is basically related with foreign filings. So patent office asks your details if you have already filed your application in some other country or you are planning to do so in future. So during the course of legal action in the patent office, if you decide to file a patent application in some other country, you will have to inform the patent office also. So Form 3 is used for this purpose. If you have already filed an application in some office in the past outside India, then you need to inform with along with Form 3. Even if later on during the course of action, during the legal process, you decide to file, then you need to take permission from the patent office and also inform by Form 3. Form 5 is basically a declaration of inventorship. So all the inventors who are involved in the in that particular invention, you have their declaration is mandatory. and that declaration is made through Form 5. Form 18A and Form 18A, see, just submitting a patent application is not enough. You have to submit a request for examination. Only if you submit a request for examination, then only your application would be considered for examination, and subsequently examiners of Indian Patent Office would examine your applications. If you don't file Form 18 along with the examination fees, your application will deemed to be abandoned. It will not be examined, and all your fees, Form 1 and the fees which you submitted before will be will not be returned. Form 18 is requested for expedited examination. Again, it's a very legal process. I'm not going to the specific at this moment, but there are two different forms. If you want to expedite your process, you have to refer or submit Form 18A. Normal process of action, normal course of duration is submitted through Form 18. If you as an individual do not want to go into all these details and you end up hiring a patent agent, you have to provide an authorization letter to that particular patent agent. That this particular authorization is provided through Form 26. So Form 26 is basically an authorization letter which is provided to the patent agent who will represent you in the intellectual property office on your behalf. So this was a bare minimum requirement. Filing process, there are two different methods. Obviously, one is physical filing. So only individuals are allowed for physical filing. There are four different offices: Delhi, Mumbai, Chennai, Kolkata. Patent agents, they are not allowed for physical filing as of now. Another is online filing. So there are two. There is a link you can refer and go for online filing as well if you don't wish to visit the patent office in all the four metros: Delhi, Mumbai, Chennai, Kolkata. Territorial jurisdiction. Well, if you are a resident of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, then the office which you need to approach for physical filing is Mumbai. If you belong somewhere in South, Andhra Pradesh, Karnataka, Kerala, then the intellectual property office Chennai is your jurisdiction. If you are somewhere in North, then intellectual property office Delhi is your territorial jurisdiction, and rest of India, including Northeast, then intellectual property office Kolkata is your territorial jurisdiction. Fees for filing, as I've already told you, there are bare minimum requirement forms: Form 1, 2, 3, 5, and 18. So, Form 1, if you are a natural person or a person belonging to educational institute, then the Form 1 fees is 1600. On the other hand, if you belong to a corporate organization, then the form fees is 8,000.
Either antibiotics nor surgery can help.
Uh, Request for examination, I told you, it's also very mandatory, without which your application will not be examined. So for individual, the request for examination fees is 4,000 rupees. For corporates, the request for examination fees is 20,000 rupees. And all the other fees, there is no fees for Form 2 if you end up restricting your convention to 30 pages and 10 claims. If you exceed that particular limit, then you will be charged extra for exceeding the 30 pages and 10 claims limit. How does the patent application once filed flows into the intellectual property office? So once you filed an application, your application will be open for public, or it will be published after 18 months. If you want to publish it before 18 months, then as I've already mentioned, you have to expedite your process, and you have to fill a different form for expedited. You have to submit a form for expedited examination and expedited publication. Form 9, request for early publication, I've already told you. If you don't want to wait for 18 months, and if you want early publication, then you have to fill Form 9 for early publication. If your application is not published, it means it will qualify for there will be three different reasons if your application is not published. One could be secrecy direction, which is imposed. Your patent is abandoned. You as an individual, you have yourself decided not to publish, so you have written an application to the office and you have yourself abandoned your application. Or probably you have withdrawn the application prior to 18 months, withdrawn 3 months prior to 18 months. So there are three different cases in which your application will not be published. Once your application is published, not once with, once your application is published, even before your application is published, along with your complete specification in Form 1, you can also file request for a publication application, request for examination along with Form 18. This form can be filed within a period of 48 months from the date of filing. So if today you have filed an application in the office, you can register or you can submit request for examination within a period of 4 years. So that is the time limit which patent office gives you. In those 4 years, you can decide whether to withdraw or whatever action you want to take. So 4 year is the time limit within which you can actually file for request for examination. 48 months. If no request for examination is filed, your application will not be examined and it will be deemed to be withdrawn. Once you file request for examination, obviously your application will be examined by an examiner in the Indian Patent Office belonging to a particular domain, and you will receive a first examination report based on what all disclosure you have made in your application. The FER, the first examination report, it will contain all the legal obligations, application, grounds of rejection or lawful grounds for objections. Also, it will contain results of investigations which examiner has found in your patent application which you submitted. Once you receive the first examination report, it is your liability to reply to that particular first examination report within 6 months. In some certain cases, 3 months time extension is also given, but you have to pay extra fees for that. You have to reply with all the objections which is raised in first examination report. Failure to reply to those objections could lead to rejection of the application. Once you reply with all the objections of the first examination report, if your patent application is found to be in order, you will be granted exclusive right patent, and this right is to prevent third parties from make, use, sell, import that particular invention. So this is a patent certificate which you will receive after your application is found to be in order. So as you can see, the patent application has a patent number, application number, the date on which this particular application was filed, name of the patentee or the applicant. So in this case, it is NIT Karnataka. The name of inventors, all those who were involved in this particular invention, the title of this particular invention. Also, it is mentioned the date, the term of 20 years from 6th of April 2022. So it defines this certificate, the validity of this particular certificate. This certificate is valid for a time period of 20 years from 6th of April 2022. Why 6th of April 2022? Because this was the date of filing, 6th of April 2022. So 20 years right is confirmed for 20 years from the date of filing. Even though this particular certificate was granted on 11th of July 2023, but then also the date of the 20 years time limit starts from the day you have filed the application. So there is another term called compulsory license, which is often this is a compulsory license which come across now and then, especially after Corona and all those medicines which were developed later on. Compulsory license. If I give you an example, there was a company called Bayer Pharma which used to produce a drug called Nexavar for treatment of cancer. The cost of this particular drug was 2.8 lakh rupees for 120 tablets. Obviously, in a country like India, this is too much. I mean, 2.8 lakh rupees for 120 tablets in a middle income country like India is too much. So the government intervened in such a situation and it provided compulsory license to a company called Natco Pharma to produce generic version of this particular drug Nexavar. Natco Pharma came up with a drug and the cost of this particular drug was 8,000, around 9,000 rupees for 120 tablets. Now, there are certain conditions when compulsory license could be provided for to another company, even if a patent holder is holding certain rights on certain technology. What are those conditions? When can compulsory license be granted? When a patented product is not available to the public at an affordable price. So as we have seen in this particular case, this particular medicine drug Nexavar was not available to general public at an affordable price. The government had to intervene and provided compulsory license to another different firm, even though Bayer Pharma was holding patent rights over this particular drug. Patent holder had failed to work the invention in the country. So suppose I am an inventor and I develop smartphone technology or a touchscreen technology, but I don't make this technology commercially available to the public. In such a situation also, government can intervene and provide compulsory license to a certain different firm or organization. in situations of national emergency, public health crisis, or in the interest of public or welfare. In such a situation also, government can intervene and provide compulsory license. What are the importance of compulsory license? It allows greater access to essential medicines and technology. As I've already told, during the period of corona and later on when various organizations were developing drugs, so this news came regarding compulsory license being provided to certain serum institute and other organization in this field, particularly important in developing countries with limited access due to high cost. So in a middle income country like India, obviously it's not possible to afford a medicine of 2.8 lakh rupees. This was all about patents which we this was all about patents. Now we'll jump to another intellectual property, which is designs. So designs relate to visual appeal, and designs relate to certain products which are only visually or aesthetically appealing to an individual. It relates to features of shape, configuration, pattern, ornamentation, or composition of lines or colors. So one of the most important question which I often come across is, so what is the difference between a patent and a design? See, you might be used. The most important thing which you need to keep in mind is a patent product always has a functional value attached to it. If a product is making your life easy, that particular product is a patented product. For example, in a kitchen, you might be having a dishwasher, a refrigerator, or induction. All these products are making your life easy. All these are part of a patented product. All these come under patent registration. In the same kitchen, you might be having a crockery set, a dinner set. All these do not make your life easy. A crockery set without beautiful designs engraved on it would also work in the same way as any other crockery set or a dinner set. The designing made on this particular utensils is only for aesthetic appeal, look and feel. It doesn't increase the functional aspect of uh, that particular product. So all those things which only increases the aesthetic appeal and does not add to the functional value will come under design regime. So that is the clear difference between whether to go for a design registration or whether to go for a patent registration. So as I've already mentioned, these are non-functional. These are only for look and feel, aesthetic, to increase the aesthetic appeal. The term for a design in patents, we have seen the term of patent is 20 years from the date of filing. For design, it is 10 years. It can be renewed for 5 years. So total 15 years duration. Where to approach in order to file a design registration? So the design wing in Intellectual Property Office, Kolkata, deals with the design registration. Also, there is an online process, so you can go accordingly. Various common designs which you might have seen across clothes, slippers, various mobile phone, the designs on sari, face mask, bicycle, car designs, dispenser, soap dispenser, trolley bags. All these are industrial design. Even the shape of water bottle and the surface pattern also come under design regime. So you have various designs and shape of water bottle which you have seen. Even a set of articles would qualify to be would qualify to come under design registration. So jewelry set, which consists of 3 different articles or 4 different articles. A crockery set I've already mentioned. A sofa set or a pair of slippers. Requirements for design protection. Obviously, it must be new and novel. It must be original. It should not be copied. Obviously, it cannot be intellectual property if you have copied it from somewhere else. Should not be disclosed anywhere to the public. Should not be used prior to the date of filing. It must be new, and first disclosure must be made in front of patent office only. The disclosure must not be made in public before disclosing it to the intellectual property office. Sorry, not patent office, intellectual property office. Significantly, it must differ from known designs or combination of design feature. It should not be contrary to public order or morality, as we have already seen in the case of patents. Section 3 deals with inventions which are against public order or morality. Not be prejudicial to the security of the country, and design cannot come, it does not include something which is trademark, property mark, artistic rights, etc., because they'll come under different kind of IPR regime, which is copyright. Like patent certificate, design certificate also, um, it will mention the date of filing and the rights which are confirmed along with that particular registration. So you can see Chitkara Innovation Incubator Foundation and everything. The third intellectual property which we will discuss is the trademark. So trademark is any word, symbol, or device which is used in business parlance, is used to identify and distinguish goods and services. The jurisdiction, as in case of patents and design, because I've already mentioned intellectual property is a territorial right, so it extends to the territorial jurisdiction in which it is filed. The term of this particular intellectual property, in case of patents, we have seen 20 years. In case of designs, we have seen 10 years, extendable to 5 years if you go for renovation. In case of trademark, it is 10 years and it can be renewed every 10 years for eternity, for infinite times. Rights conferred by registration. So, like it provides you with exclusive right to use the mark for registered goods and services. What are the specifics? I'll discuss in subsequent slides. So rights can be of trademark rights can be of various different types. There could be a word trademark. For example, Google is a registered word trademark. New York Times, there is a certain way in which this particular New York Times is written, so it is a registered word trademark. Coca-Cola, Nestle, Bisleri, so all these are registered word trademark. Design trademark, for example, a Twitter logo or a Nike logo, CNBC, Domino's, Microsoft, all these are design marks or design trademarks. Combination mark could be a combination of design and word. So, for example, a design mark of Nike and symbol combined with on combining these two, we'll get a different kind of combination mark, which is again a registered design trademark, registered trademark. Sorry. There could also be collective marks. For example, Tata as an organization has so many subsidiaries. It has Tata Steel, Tata Sky, Tata Power Solar. So Tata as a logo has a main holding company, and all the other subsidiaries combined together will correspond to a collective trademark. Then there are certain certification trademark, eyesight trademark, foresight trademark, the green and brown color dot which are found on vegetarian and other products. They're also come under certification trademark. The shape trademark, the Cadbury Kit Kat trademark, or the color trademark of purple color, which is of Cadbury. All these are different shape and color trademark. The sound trademark, the 20th century fox or the drum and trumpets, which you find in various Hollywood movies, the sound of Britannia Industries or the Nokia tune, or all those things are sound trademark. How to indicate your trademark? So there are two different ways of indicating your trademark. First is unregistered trademark. There are unregistered trademark could be represented using this particular TM word. If you apply, even if you don't go for registration, or if your application is pending in the intellectual property office, then you can indicate unregistered trademark through this particular symbol. When it is a registered trademark, obviously you will find this particular symbol on various products, so it is a registered trademark symbol. There was a very famous incident which happened a couple of years ago related to Paradise Biryani, one of the famous food joints in Hyderabad, where local shop owners were using same name, Paradise Food Court, and they were actually hampering with the business of this famous food joint. So Paradise Chain filed a case in Telangana High Court, and ultimately trademark infringement case was registered against local food joints. They had to give up Paradise keyword, and they were also authorized to pay damages to this particular food chain. Recently, in March 2023, there was another dispute regarding to Jain Shikanji, which is another shikanji, basically a masala or a lemon drink, quite common in areas around northern UP Bihar belt, Delhi. So again, similar case, you can actually refer to the article of Indian Express and get an idea about it. So don't use it interchangeably. Trademarks basically refers to uh, all those things which are part of trade and commerce. Patents related to inventions. I've seen people interchangeably using trademark, patent, design, copyright. So trademark specifically deals with something which is related to trade and commerce. What are importance of trademark protection? Obviously, it protects business from trademark infringement. It builds and maintains strong brands through consistent and high quality product and services. So if someone has mentioned Paradise Biryani on their particular product, you will obviously get to know that okay, this belongs to a particular reputed food chain, and this less likely to be uh, that kind of quality and hygiene is maintained in that particular product. Consequence of infringement on another party's trademark. So if someone infringes your intellectual property, you're liable to take actions against them. Conclusion: trademark protection is important for business. It maintains the brand identity and prevent confusion among the consumers. Registration of trademark. So obviously you have to file an application in the intellectual property office. Examination will be done. If someone oppose your trademark registration, obviously during the course of action, he or she can approach the intellectual property office and oppose that particular step. Registration, as I already mentioned, is a period of 10 years and it can be renewed for lifetime, infinite time, renewed every 10 years. Uh, the second last intellectual property which we'll be mentioning today is copyrights. Copyrights, again, it's an exclusive right given by law for a period of time. It is provided to authors, composers, artists. Right which are enjoyed by the copyright holder is right to publish, print, sell copies of the original work. Being a territorial right, it extends to whole of the India. For most of the works, the lifetime of intellectual property copyright is lifetime of the author plus 60 years. So, like most of the works of Mahatma Gandhi when he died in the year 1948 became public 60 years after his death. Terms of protection, as I've already mentioned, most of the works, the term is lifetime of the author plus 60 years. So, in case of literary, dramatic, artistic, and musical work, the lifetime was lifetime of the author plus 60 years. For cinematographic, film, and sound recording, it is 60 years from the date of publication. For broadcast reproduction right, basically TV and radio broadcast, it is 25 years from the date of broadcast. For performance right, if stage show performance or any public performance, it is 50 years from the year following the year in which performance is made. So, in general, it is lifetime of the author plus 60 years, but there are specific situations wherein it may differ. Who all are the authors? So, quite obvious, for literary and dramatic works, the author, the person who has written that particular literary or dramatic works. For music work, the music composer is the author. For artistic work, other than photographs, the artist of that particular artistic work, the painter, or the photographs, the person who is taking the photograph. For cinematographic act, the producer of that particular recording or cinematographic film. For literary dramatic work, the person who causes the work to be created. Again, there was a very famous copyright infringement lawsuit in filed against Delhi University and a photocopy services belonging to Delhi University campus. So basically, the professors in Delhi University were using copyrighted material of famous international publishing house, Oxford and Cambridge universities, and they were selling those notes as a part of uh, class notes to the students. And a nearby photocopy shop was copying those, selling those particular photocopied material publicly. Obviously, the International Publishing House approached and filed a lawsuit against not only Delhi University but against the photocopy shop as well. Publisher argued that this constitutes a right of violation of their intellectual property, and they asked for injunction against the university also and the photocopy shop as well. Delhi University and the photocopy shop mentioned that there is a special provision in the Copyright Act where fair use of copyrighted material is allowed for educational purpose. So Section 52 of the Copyright Act allows free use of copyrighted material for educational purposes. Obviously, on basis of this particular section, Delhi University and the photocopying shop made an argument in front of Delhi High Court. So in 2016, Delhi High Court ruled in favor of Delhi University and the photocopy shop. The case was again taken up to the Supreme Court later on. Supreme Court declined to hear the case, and effectively later on this case was withdrawn. So what I'm trying to say is, fair in Section 52 of the Copyright Act permits limited use of copyright material without owner's authorization. Basically, for educational purpose, their fair and equitable use of copyrighted material is allowed. There's no problem in that. Geographical indications, again, one of the very important intellectual property. Before starting, before going into the specific of this geographical indication, I would ask, I will show you a video which would give you a better understanding of this particular topic.
चिमनी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाह नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता, तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा ताना सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता।
एक्सेप्ट किया तेरा कॉम्प्लीमेंट। तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बिना मस्का?
मस्का नहीं नानी, आप सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड।
अच्छा,
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियां देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूंगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक है। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
अरे छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है? क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी, एक बात बताओ, इस जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआई गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So IP Nani, mascot of Intellectual Property Office. Uh, there are various, as you might have seen in the video as well, various registered geographical indicators, which is Darjeeling tea, Makrana marble, Ratlam save, Kanchipuram silk, Katputlis of Rajasthan, saffron, Madhubani paintings, Naga mirch. These are all registered GI tags. Kinnan toys, Mysore agarbatti, Mysore Pak, Kurg oranges. We into the last leg of this particular session, so I have another video for this particular towards the end. So all of us think that inventions could be something which is extremely new and very complex. Even a simple paper clip could also qualify to be an invention and would be granted patent. So this particular paper clip invention, which was the inventor was W. Cole, and this particular paper clip was granted patent in 4th May 1897. So don't think that you need to come up with something big, large, or something complex. Only then you will be granted a patent. A patent can be anything which solves the purpose, something new, something innovative, uh, has a functional value attached to it. You will be granted patent, as simple as that. In order to summarize, patents granted for 20 years, there is no concept of global patents or international patents. Designed for 10 years, extendable to 5 years if renewed. Trademarks for infinite period of time, in a cycle of 10 years. Geographical indicators, indefinite, subject to renewal every 10 years. Copyright, most of the cases, lifetime of the author plus 60 years. There are certain exceptions to it as well. Who can apply? There are 4 cases: true and first inventor, assignee, legal representative of a deceased person, or patent agents. There are various methods through which you can apply. Person includes firm, partnership, firms, small entity, anything. All IP rights are territorial. I've also mentioned there is no concept of global patents as such. See, the first thing which you need to keep in mind is before making your invention or your intellectual property public, first approach the intellectual property office and register for it, and then make it public. One of the most challenges which we face in day to day, I mean, the intellectual property office faces the inventor, especially in India, they don't have knowledge, and firstly they publish their invention, and then they approach intellectual property office and ask for patent specific for a patent registration. This is a wrong strategy. Firstly, you should go for protection and then go for publishing your intellectual property work. Rights are territorial. I've already said this a couple of times. Registration is done by the sovereign authority. In case of India, Government of India or the Intellectual Property Office, there is no other way for getting the registration. Rights are limited for a period of time. In some cases, it is infinite, provided you pay for renewal fees. There is no automatic relief. The Intellectual Property Office will not provide. You will have to file an infringement suit on your behalf only. Renewal fees obviously is needed, even in case of patents as well. Appointment of patent agent is not compulsory. Most of the people think that patent agents, you need to have patent agent in order to register. No, as an individual inventor also, you can approach the office and directly communicate with the authority over here. So if you need any further training on this particular on each intellectual property, for example, most of us ask for patent filing process, all those details. There is a training institute, Rajiv Gandhi Intellectual Property Management Institute, Government of India. You can directly contact this particular institute. Also, this institute runs various patent drafting, patent copyright related intellectual property course time to time. You can also register for them. The courses are both online and offline. So obviously you will get details of it. You should visit the website or you can contact depending upon your. If you have any other questions, you can connect with me on my email ID vikramsingh.ipo@JU-FET.in. Also, you can connect with me on LinkedIn. So yeah, that was all from my side. I hope you enjoyed the session and found it interesting.
Thank you so much, sir. This was indeed a very wonderful session, and this was much needed for our institutions because we have more than 300 faculties in Jain group of institutions, and we have our institute widespread throughout Bangalore. So we may have more than 10 campuses in Bangalore. So this is very useful for us, and we really look forward to have many more such sessions in our college. And thank you so much, sir. So if anybody has any question, then we can just take up one or two quick questions.
Someone asked regarding slides. I'll provide the slide to the coordinator, madam. You will get the slides.
Okay, perhaps there are no questions.
Hello.
I would have,
Hello.
okay, somebody. Yeah, yes, sir. Please go ahead.
Yeah. Hi, sir. I'm Professor Lenin Babu from Design School. I have a small question. You mentioned about the bottle shape and aesthetics, right? So there, if there is a need of shape change or aesthetic change, which it is used for the purpose of end user experience. Let us think in that perspective. Is it as patentable or design registration?
Yeah, this is a very, I mentioned this particular thing in the slides as well. See, you just need to ask your particular invention, whatever you are developing. If that particular product which you have developed, if it is making life of the end user easy, if it is has a functional aspect, then it will qualify to be a patent invention. On the other hand, if it is only for look and feel purpose, it is not making life of the individual easy. It will just be a design thing. It will not come under patent registration. So it's very easy to differentiate between the two things. Yeah.
Yes, sir. Thank you, sir. Thank you very much.
Thank you so much.
Oh, thank you so much, sir. So we really thank you from the side of Jain University. So let's just end this session. Thank you so much.
Thank you everyone. Thank you so much, ma'am. Thank you so much.
Thank you, sir.